This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Jean Acevedo. Ms. Acevedo is a licensed healthcare risk manager, certified professional coder, and the owner of Acevedo Consulting, a full-service healthcare compliance firm specializing in coding and third-party payer billing. Additionally, Acevedo Consulting maintains a robust expert witness practice with numerous engagements relating to fraudulent billing and overpayment appeals. Ms. Acevedo, thank you so much for joining me here today.
My pleasure. Nice to be with you, Noah.
All right. Well, let's just jump into it. You started Acevedo Consulting in 2000, I believe. How did your practice begin? Had you served as an expert witness prior to starting the firm?
No, I had not served as an expert witness prior to the firm being founded. I doubt that when I founded it, I even thought about that as a quote unquote business line. But I happen to have been lucky enough to know a few good, prominent healthcare attorneys. And somewhere along the line in the early years, in 2002, I think it was, I got approached by a prosecutor for the state of Florida for a billing fraud false claims case.
Oh, okay.
Yeah, and I remember thinking, oh, wait a minute, they're looking for a witness for the state of Florida. My consulting business's clients are doctors. Can I do that? That was it was a difficult decision actually to make, because my first thought was, wow, would the doctors think I was a turncoat? Right? If I was serving as an expert against another physician. But then I realized, since the focus of the firm is really compliance, that meant that I needed to stand up and not be afraid of getting the bad guys out of the system, right? So sure. That was my first engagement, and I found out during the court case that there is a process to actually being deemed a witness. Deemed an expert. So okay. The judge actually deemed me an expert in physician documentation and coding while I was on the stand, right? Which is so fascinating. It was like, oh wow, just because he said so, now I'm an expert. Yeah.
Sure.
But and it was an interesting case, and I felt good that I was able to help get one of the quote unquote bad guys out of the system, right? So yeah.
I want to touch on something that you mentioned. You said that you were unsure of whether to take your very first case. And it's interesting. You bring up, not only, do you have to make sure that you are an expert in the area that you're approached to be an expert on, but what effects that might have on your career. That's not something that I've talked about on this show very much. Can you walk me through a little bit of that calculus?
Sure. So I had started the business to provide for primarily small physician practices. That's not the case today, but for small physician practices to have an effective compliance program. Sure. Do education, write their policies. The Office of the Inspector General's physician compliance guidance had come out within 2 months, I think, of the business being incorporated, right? And I knew that there were plenty of large firms that would charge a physician 5 figures minimum to come in and help them do that. But there were plenty of small physician practices without those resources that were up against the same regulatory environment, right? Just the matter of doctors, right? The system's the same regardless. And so when I was approached, my thought was, approached by the state of Florida, well, wait a minute, if I'm here helping the physicians, will they think that I am a traitor, right? If I wind up testifying against another physician. But then I realized that actually the opposite was true. Because the moment that I broached that topic with a physician to test the waters to see, okay, am I going to be out of business because of this one court case? The reaction was one of, oh, then you bring extra insight to your work with me. And I was like, sure, yeah, that's it. So, but it was true, right? Because the experience did give me insight as to what is it that, in this case, it was the state, but what is it that the investigators are looking for, right? What's the difference between fraud and an innocent mistake? Because our healthcare reimbursement system is so complex, it's fraught with risk for mistake.
Sure.
And there's a big difference between innocent error and a false claim.
Right. Of course.
Yeah.
So is this something that you've had to struggle with going? Do you have to turn down a significant number of cases, or have you turned down cases, since then?
I've only turned down one or two, and that would be because I had a conflict. So for anybody who's actually just starting this, the question in my response makes me realize that that's a real important thing to realize. That if you've got a relationship, personal or professional, with the entity, either plaintiff or defense, or some individual or another entity that is, in my mind, because I'm real strict about the ethics of this,
Sure.
even vaguely related, it would be difficult to be an objective expert, because I do think, besides being a subject matter expert, right? So,
right,
that would qualify you as an expert, that your independence and objectivity has got to be paramount. It can't be that, well, I know this doctor, I know this CEO of the hospital, so, and because what one realizes quickly, as I did, the first couple of times I was deposed, is that the side in the case that's taking your deposition is not your friend. I mean, I've had depositions that were maybe 2 or 3 hours. And then I remember the first one early on that was 8 hours.
Wow.
And when I left that deposition, I was mentally exhausted.
Sure.
My son had come home from college and was in the house. And I remember calling him and saying, okay, it's finally over, which he was shocked that that's where I'd been all day. I said, I need you to order me a pizza with pepperoni and extra cheese, and please put a Coors in the freezer.
Nice.
Right? Because I was so stressed out. I remember the feeling of someone trying to discredit me.
Mm-hmm.
Right? Either my expertise, my knowledge of the case, my opinion that they were getting me, to state on the record. And that was the most difficult deposition, not only for the length of time, but for how brutal the lawyer was.
Sure.
But then, as in so many things in business, I realized that I was either going to say, well, that's it, I'm not going through that again, or realize that that attorney was doing his job.
Sure.
Right? He's representing his client, which is the opposite side of what I was representing, right? And his job was to discredit me, find holes, something that would get his client, either, depending on which side, right? Either not guilty, lesser penalties, whatever it might be, right? So, and I realized it was just business. In fact, that's a good lesson for anybody that's just starting.
Sure.
Don't take it personal, right?
How important is the preparation when it comes to that? In other words, were you kind of caught off guard with that long 8-hour depo? Did you feel prepared going into it for what might happen, the kinds of questions they might ask? Did they do any mock cross-examination or anything like that to prepare you for it?
So that's a great question. And at that time, and that was fairly early on in my career, the last 20 years about doing this. And okay, the answer to all of the questions would be no. No, I did not feel prepared. There hadn't been any mock, cross-examination, etc. So hopefully all of us in our personal and professional lives take experiences and learn and grow from them, right? So that was one of the occasions where I realized I needed to step up and ask more questions of the attorney I was working with.
So
Um,
you feel that an expert really needs to take a proactive role in the preparation.
oh, most definitely. In fact, there was a case not that long ago during the pandemic, right? So within the last 2 or 3 years, that I felt like the attorneys were limiting what I was being given when it came to information.
Interesting. How so?
Yeah, so because I kept asking, I don't know if this case was ever settled or whatever, so I don't want to say anything because of the narrow specialty. So it was a physician who was being charged, and in fact, this is such a common situation nowadays with billing for services that he didn't provide. And the billing requirements for something called Incident 2, where his name could be on a claim when one of his staff had actually provided the service. The circumstances for that had not been met. And I started getting little red flags. Oh, that's probably another thing for anybody doing this. Follow your instincts. Because I started getting little red flags that something didn't seem to make sense. And I had done work with one of the 3 attorneys representing this physician before. So even though I'd started off at the comfort level, I was not totally comfortable. I actually started getting a little bit suspicious that I was being fed the information that was beneficial to the client, but not necessarily in the long run. Because again, if I'm deposed somewhere and I say, well, Miss Acevedo, didn't you know that? Right. And I say no. Oh, I look like a friggin' idiot.
Right.
There goes the credibility. And I did have that happen to me once, So the moment I started asking for more documents and supporting evidence for the position, one of the positions the attorneys were taking, I got radio silence.
Ah, interesting. So you felt that there was some funny business going on.
Yes.
How did you deal with it? Did you walk out of the case? Did you still complete the engagement?
So, these engagements are kind of open-ended for the most part, right? They either want an expert report or they don't. They either you get deposed or it turns out that you don't. Things get settled before. I've been an expert in civil litigation where based on my expert report, there's no depositions. Suddenly everybody's settling, right? So it's like, okay, good. I guess like pretty good with the pretty good wordsmith, right? So
Sure.
it's laying out the truth and the facts and the background information correctly, right? But so with this particular instance, what I finally did, because I realized, okay, I don't know if there are deadlines that I'm going to be held accountable towards, but I have had this, what I'm calling radio silence.
Sure.
So, and I also realized that it probably wouldn't be that the lawyers would say, no, Jean was okay, right? She was on top of stuff. It was us. So I said, okay, this is not leaving another voicemail. This is an email, So, and I don't necessarily like to use email as a CYA, but to make sure that what you're saying is on record.
Yeah, preserve it. Sure.
Yeah, right. So I finally wrote, I had before and I had called and I'm like, I'm not getting a response. Something tells me that what I've asked for, they don't want me to have. And if I'm their expert and there's something I can't have, I'm not going to be used, right? And be
Sure.
embarrassed or anything else in a deposition or in court of law, et cetera. So I finally did write an email and saying that, I've tried several times to, have you see if you could get me X, right now I'm going to assume that X doesn't exist or you're not able to get a hold of it. So I'm going to stop my work. If anything comes up, right, that you still need my assistance, please let me know, and ended it very nicely.
Sure.
I don't know the circumstances if there really was something, and I never heard another word. So I think my instincts are probably pretty good.
Wow. What advice do you have for attorneys to avoid kinds of situations of this manner? And obviously, the other side of the coin is what can experts do to kind of vet the cases that they take in advance to avoid these kinds of situations, or can't do? Is it just too much of a moving target to be able to always do that?
So that's the last part of your question is really interesting. How do you vet to make sure that you don't take something that's a losing battle, right? Because you also, as an expert, don't want to find yourself 2 months in where you've wasted somebody's time and money, right? So part of it, I think it's a twofold answer for avoiding that. One is make sure you're comfortable with what you're an expert at. Because I have turned down cases where it's something in an area, so maybe with hospital billing, et cetera, right? And I'm going, tell me a little more. And I'm going, no, I'm not an expert in that field. So, let me know if something else comes up and more the professional billing, right? So,
Sure.
knowing where you are not an expert, right? You really don't want to go down a path where you're not. That could probably be the death knell to your career. I would imagine. But then I've also learned through the years that, okay, once I've got a case, being two things. One, being totally upfront with whether or not you think there's a case that you
Okay.
can, there's one. I'm in Palm Beach County, Florida, and there's a criminal defense attorney here who is extremely well known. His name will not be mentioned. I served as an expert for him in a federal fraud case, and that case, had as good an ending as he or even the provider could have hoped. And he reached out to me once or twice after, and in each time I was like, oh, that's so wrong. I can't help you. Right.
Oh,
And
interesting.
I'm like, no, I can't. Nope, this is just wrong. This is a violation. I can't even figure out how to put lipstick on this. Right. And I remember being at an American Health Law Association Academy meeting a few years ago. And coincidentally, this lawyer sat down next to me in a session. And it was like, oh, hi, how are you? And oh, hi, Jean, yada, yada. Wound up having lunch with, I think, two other attorneys, and the attorneys asking me what I did. And this attorney that I'm referencing actually said, Jean's a real good expert, but she won't, and now I'm paraphrasing, and I don't want to misquote him or any other attorney, right? So, but
Sure.
she doesn't necessarily take the path, and I know this isn't exactly how he said it, but the meaning's the same. She won't necessarily go down the path I want her to go, so I can't use her as much as I'd like. And I remember sitting there at lunch and in my mind thinking, I consider that a badge of honor.
Exactly. Right. I mean, because as an expert, you're supposed to talk about a moment ago, you mentioned, how important it is to know what you know. And know
Yeah.
what you're an expert on and not kind of go outside of that. I mean, you've spent a significant amount of time becoming certified, and I imagine retaining those certifications. You hold 4 distinct professional licenses, and you're an AAPC fellow. Is this kind of licensure, is this the kind of thing that attorneys look for when they're hiring you, or are they looking for your record, your battle record for how many cases have been won when using you as an expert?
So the attorneys that reach out to me and that I work with have never once questioned anything about my credentials. For them, it's always, we read a couple of your reports. They got on whatever database attorneys use where they research, right? And we like the format, we liked your approach, right? And it's the other side, though, that will,
Do the oppositional research.
yeah, do the oppositional research, try to see if, question how this credential has anything to do with what you're talking about, or, and But yeah, but because in this field, there isn't a degree in compliance, right?
Right.
There isn't a degree in coding. You can't have your master's in medical coding, right?
Right. Right.
And because I think it is important, and people do have it's that first impression, right? I'm going
Yeah.
to a doctor, but he doesn't have DO or ND on the end of his name, right? So wait, is this really a doctor? Just this subconscious human reaction, right? That
Sure.
you have credentials, right? I think is important. And I know when I'm asked about mine, and oh, by the way, folks, when you're in a deposition and they do the background questions, this is your time to toot your own horn.
Mm-hmm.
So I
Give
know
them the
when,
full alphabet soup.
oh yeah, so I know when they say, well, what's a CENTC? I said, oh, I'm a certified ENT, ear, nose, and throat coder. But I didn't take the exam. I actually sat on the steering committee that wrote the exam for the academy. Yeah.
Nice. Excellent. Excellent.
Yeah. So some of those things can be very helpful. And where is it that shows, right? Besides you saying so, that you're an expert,
Sure.
right? And yeah, you alluded to continuing education. Yeah, there's a fair number of CEUs that you need when you have more than one designation credential from the AAPC or a HEMA, and in coding, those are the two recognized
In
certified.
general, in general, how can other experts who are maybe not in the healthcare field, use that advice? What's important when you're advertising, and not that you necessarily advertise, but what makes you look good as an expert? Why do attorneys come to you? Is it like you said, because they look at your past reports and they've been of high quality and on the winning side, or is there some other mechanism that you use?
So we do have a website for the firm, for Acevedo Consulting. And as anybody would see, it's not plastered with anything about expert witness.
Sure.
It's good work. It's challenging work, right? But I'd probably have brain burnout if I did it every day, because can be such challenging work. So having a website and making sure that you have some understanding of the wording, that if someone's doing a search, that your firm or you personally, if you're just independent, would come up as a response to the search is
Sure.
probably the most important thing. We get a fair number of attorneys when we'll ask, so how did you hear about me? Oh, I was doing a Google search,
The
and
old SEO.
yeah, right. So, and little known fact, I did have a year and a half in a healthcare internet technology company a long time ago. So I have enough knowledge of planting words, et cetera, and embedded in the website to be dangerous, but apparently also. So, so it's that, and I don't know about advertising. I've never advertised, so I can't speak to it other than the
Sure.
website, right? And presentations. If you're trying to develop this type of a practice as an expert, if there are meetings of some of the more highly recognized healthcare organizations, the Healthcare Compliance Association, American Health Lawyers Association, things like that one can speak at, your audience is liable to be the attorneys who could be calling you, right?
Sure.
And there's something about being a presenter that, unless you just suck, sorry, right, but unless you're just really bad, that you're kind of looked at as an expert to everybody who's in the audience. Otherwise, why would they be listening if they didn't think you knew what you were talking about? And the fact
Sure.
that the organization may have asked you or is paying you to speak, et cetera, kind of puts that seal of an expert, right? on you and your topic at least. So those are some really good things to do. And one of the things I believe for myself that has been helpful when I'm deposed is that I take cases both sides. Right. So no one can ever say that, well, she's just a shill for the doctors, right? So
Right.
no, I mean, I do work for the Department of Justice, investigative consulting, expert witness work, and the FBI, as well as the local, or not so local physician group or other healthcare provider, right? So
Sure.
I think those are some of the important things. And I think this goes with an answer that I didn't give you completely before, Noah, about a question you were asking is be curious. Be curious. Ask plenty of questions. Don't let the attorney tell you that, no, you don't need to see that. Because if that attorney had your expertise, they wouldn't have called you in the first place. And if someone else's deposition or the interrogatories or something that is in the file on this case, whatever this case might be, when I know many times when I've read, I go, oh my God, I didn't know that. Right. And then call the attorney and say, oh my God, there's this little hidden gem, in this other document. Right. So be curious. Realize that you are the master of your destiny in this case when it comes to what the expert is doing, right?
Sure.
And that the lawyers are hoping that you'll do for their client. So you need to really lay out the plan from your perspective and stick with your guns.
When you're writing the reports for the attorneys, do they come to you in kind of a skeleton format where you're filling in your opinions on technical issues, or are you writing them whole cloth?
So I'm typically writing them whole cloth.
Okay.
Right? So there might be like a rebuttal to, because when you start writing a report, the other side has its experts that might write its report and trying to dispute your report. And then you're doing a rebuttal to that other expert's rebuttal of yours. And by the time you get into some of those rebuttal reports, you may indeed have the attorney making some suggestions as to a path, right? Not to feed you knowledge, et cetera, but to how best to mount your argument.
Sure. And that's kind of that's why I'm asking the question is exactly that is, do you ever feel overly influenced? How much do you have to typically push back on attorneys when it comes to report writing?
It's been rare for me to have to really push back.
Okay.
I'm lucky, right? That the attorneys that I've had the pleasure of working with, that it's more of a collaborative agreement, right? So arrangement. And one of the things that I know I didn't know for the longest time was that depending on the type of case, civil lawsuit, criminal defense, this, that, and the other, there are different requirements for the reports. So you also need to make sure that you're open, unless you think you really know this stuff, right?
Right.
The technical underpinnings for a case and what type of reports and when they might be due, et cetera. One needs to be open, because I'm glad I was, because otherwise I would have had the wrong formats for things, right? Some levels of the some requirements of some cases, depending on the type of case and the court it's filed in, et cetera, have very specifics that are required to be in the report, and basically a format that you have to stick to.
Do you find that the attorneys have been reasonably communicative in terms of letting you know what those boundaries are in the correct format and all of that?
So that's another great question, because I think I've realized that not necessarily, and it's not because they're being, excuse me, remiss or anything, but I think because it's something that they really know. Right? That they're kind of assuming that I know, right? So it's like, I know how to drive a car. If this is when you're learning, I may forget to tell you to put your blinker on, because I'm going to assume, right, when you're going to make it, So I have learned, and this goes back to my statement about be curious.
Mm-hmm.
So, because there have been many instances where I've asked at the beginning, so tell me, are there reports that are going to be required? Are there specific points within this litigation that I'm going to need them? Are there specific formats, that I need to stick to, et cetera? So I've learned that I need to be curious, right? And not assume that because something wasn't stated by the lawyer that it doesn't apply, right? So it's also up to the expert to know what he or she needs and to voice that.
That's excellent advice. Before we wrap up, I'd like to pivot to winding up the engagement. Do you typically follow a case to its conclusion? Do the attorneys keep you abreast of where the case is kind of in general in progress, if it's near the end? And are you concerned with winning at the end of the case, or you've already moved on at that point to your next engagement?
So, well, I'm definitely interested in winning, right? I'm hoping I've done something that helps the case be won on the side that I'm representing, right? So, as far as following the case, I do want to know how it turned out, right? And sometimes attorneys automatically do that. I found that in cases that go to trial, right, the lawyer that I'm working with is most times going to probably even call me. I've gotten Friday night calls. We won, right? Or not guilty on 4 counts, because it is so important to the client, right?
Of course.
Yeah. And I've not found an attorney that minds following up, right?
Sure.
So, and if you're trying to market your bit, I'd never thought about it this way. I'm just naturally curious. I want to know, so what happened, right? But I'm
Right.
sure that if I was the attorney, I would look favorably on someone who didn't just do their job and then moves on to the next, right? That actually
Absolutely.
has an interest. So,
And finally, when you are wrapping up, I'd like to touch on billing really quick. Do you typically bill by project, by hour, some combination thereof?
um, with expert witness cases, my experience is that the amount of time and expertise that is needed is all over the map.
Sure.
So I've not been able to find an equitable way to put a project fee. So bill hourly.
Sure, for everything. Do you take a
Yeah.
retainer or anything like that?
Yes, and definitely a retainer. Lawyers, but when you're an expert, the lawyer is typically paying, right? And most
Sure.
lawyers don't want to put their law license at jeopardy by stiffing someone. So, but they also understand establishing credit by getting a retainer. They do the same thing, right? So that's one good thing. You're not speaking a foreign language to your client being the lawyer or the law firm, right? They understand retainers.
Of
So
course.
getting a retainer, and then billing hourly. And then I would say, because I've had not too many, just a small handful of cases that were over long before one would have thought, right?
Sure.
Yeah. So making sure that you're also very good about returning any unused retainer.
Uh-huh. Sure.
Right?
Of course.
Not your money. So yeah. Yeah. But I think
That's
hourly, I'm not quite sure how anybody could do a project fee, right?
okay. Finally, do you have any last advice for new experts or attorneys that you'd like to leave, that you'd really like to hammer home before we sign off?
So the one message which goes both for the attorneys and any new experts is, for the experts would be, again, be curious, ask questions. Don't feel like, oh, maybe I should know this. I don't want to ask. I don't want to look silly, right? There are no stupid questions, only ones that you haven't asked that you're going to kick yourself that you hadn't asked 3 months from now. And for the attorneys, remember that you're probably not working with an attorney.
Right.
So making sure that your expert feels comfortable to actually ask you questions and ask you about procedures and processes, without making the expert feel silly, right? Which was why she didn't want to ask you in the first place. And making sure that on both sides that you work collaboratively, right? You're all working towards the same goal, hopefully have a good result for the end client, whoever it is that is being represented in whatever action it is. So, yeah, and for the newer experts, budget your time well. Ask upfront. Boy, that was a lesson I learned after having pressure to get something done. And I'm like, oh my God, if I'd only asked whether or not there was going to be a report, right? And when I never would have had these other projects I was working on, because now I've got to burn the midnight oil to get this report done on time, right? So because it's not a matter of calling the court and saying, can I have another week? Doesn't work that way. Right. So time management is important for the experts as well.
Absolutely. That is excellent advice. And thank you so much, Miss Acevedo, for joining me here today.
My pleasure, Noah. I enjoyed it. Thanks.
And thanks to our listeners for joining us for another discussion at the Roundtable.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.